The defense in the trial of Derek Chauvin turned their focus toward George Floyd's drug use during yesterday's cross-examination. Attorney Eric Nelson argues drugs in the 46-year-old's heart condition led to his death, not the force used by the fired Minneapolis cop. An autopsy found fentanyl and methamphetamine were in Mr. Floyd's system when he died. Yesterday, jurors heard from several witnesses, including forensic scientists who investigated the scene where George Floyd was killed. For more on this, let's bring in attorney Paul Batista. Paul, we saw defense attorney Eric Nelson attempting to show George Floyd yelled, "I ate too many drugs," as officers pinned him to the ground using body cam video. One witness, senior special agent Jamie Ryerson of the Minnesota Bureau of Criminal Apprehension, initially agreed with the defense that that's what Floyd appeared to say. But then he changed his answer when the prosecutor, Matthew Frank, played a longer clip of the video. Let's play that.
Having heard it in context, are you able to tell what Mr. Floyd is saying there?
Yes, I believe Mr. Floyd was saying, "I ain't do no drugs."
So it's a little different than what you were asked about when you only saw a portion of the video, correct?
Yes, sir.
So what impact could that revision of judgment have on the jury and how the jury perceives this witness and what they are seeing and hearing, Paul? And also, should the prosecution have objected? I don't know. I'm not a lawyer. But when it sounded to me as if what the defense attorney was trying to get the witness to do was to agree with his interpretation of what he believed George Floyd was saying, not asking him, hey, what did he say? He said, hey, did he say this? Don't you agree that that's what it sounds like? Wouldn't that raise an objection if you were on the other side of that?
Not really. After all, let's remember, this is a terrific. It's a tragic trial, but it is a marvelously presented trial. The defense is doing extremely well. The prosecution is doing overwhelmingly well. But this is fascinating. A prosecution witness, an expert, is clearly saying during the defense cross-examination, which is handled beautifully and appropriately and without objection, the prosecution witness is hearing and saying George Floyd articulating as he's lying on the ground toward the end of this episode, "I ate too many drugs." Now, it is true that within seconds, the prosecution, realizing just how, I don't want to say devastating, but critical this can be, replays the tape. And what does the prosecution witness do? He backtracks. Whether I believe what I heard, or you believe, lad, what was heard, or there's a conflict, what matters is what the 12 members of the jury heard. And I think it is going to play a role in their determination of the case, particularly when we remember the defense. And let's not forget all of the other evidence. Look, I'm not in either side of this. This is a fascinating trial. It's a tragic event. But a lot of evidence has come in here through the prosecution that, in my view, is quite helpful to this extremely skillful lawyer representing Derek Chauvin. What matters, Vlad, is what the jury heard.
The defense asked permission to present an arrest of George Floyd from May 2019, which the judge initially denied because it was not relevant to the case. But now, Judge Cahill has agreed to allow the defense to present a portion of the body cam video from 2019 and testimony from a paramedic who treated Floyd. Why might have the judge changed his mind on this, Paul?
Well, first of all, a basic principle is Derek Chauvin, in effect, is on trial for his life. There's no death penalty involved here, but a term of 40 years is a life sentence. Generally, when you're attempting to present a defense, you're generally allowed to present anything that is remotely relevant to a claim of innocence by your client. Now, this is a very capable judge. If he's made one decision, but on hearing now many days of evidence, that it's appropriate to introduce evidence of a fairly recent event involving George Floyd's life, why not let the jury hear it? If the judge were to preclude it and Chauvin were convicted, it would create a critical issue on appeal. So I think the judge is really kind of not only being fair, not only being appropriate, but protecting the record.
Paul, we heard the prosecution ask Sergeant Steiger about the principle of pain compliance. I want to play a little bit of that.
How would this positioning induce pain?
This can induce pain a couple of ways, either by squeezing of the fingers and bringing the knuckles together, which can cause pain, or also basically pulling the wrist into the handcuff, which can cause pain as well.
In the principle of pain compliance, if I'm to understand your testimony, you would inflict pain for the purpose of having the subject obey your command.
Yes, comply.
What if there's no opportunity for compliance?
Then at that point, it's just pain.
Explain what the prosecution is trying to do here, Paul.
Well, I think the prosecution is trying to show that there were many opportunities to handle this situation a little bit differently, but that Chauvin ignored the multiple opportunities he had available to him and exerted pressure, ignored his training and exerted enough pressure on George Floyd to be the cause of his death, to have committed a murder. And pain compliance is, hey, I've learned a lot about in the last few weeks about techniques of police control, trying to bring arrestees under control. And pain compliance is yet another bit of nomenclature that we've heard through the whole course of this trial.
During cross, the defense highlighted a Supreme Court case, Graham v. Connor. Explain the significance of this ruling for the case.
Well, actually, this ruling of the Supreme Court is, and it's important to keep this in mind, and this raises this issue. When the judge reads the charges, not the charges, but reads his instructions to the jury is going to be told, based on this decision and others, that the police, in executing an arrest under trying circumstances, have to rely on any number of emotional, if you will, or adrenaline-driven factors. And they're given fairly wide latitude. This is what the jury is going to be told. You can't judge Chauvin's conduct by how you may feel sitting in a jury room, or how a judge may feel sitting on the Supreme Court bench. We're talking about, in the case of an arrest, police who are in a situation of combat. That's why you hear the defense lawyer, Nelson, constantly referring to a fluid, highly dangerous situation. And that's the Supreme Court decision. Frankly, many of these decisions from the Supreme Court and other state courts provide a lot of discretion to the police in making arrests. So the jury is going to hear that, in effect, it doesn't have to give the benefit of the doubt to Derek Chauvin, but it has to take the circumstances that he faced into account, not the circumstances the Supreme Court may have faced when it was reviewing a litigation. And I think that's the significance of the decision. The jury is going to hear a lot in the instructions that are arguably favorable to the conduct of not just Chauvin, but other police officers.
All right, Paul Batista, thank you. Appreciate it.
Always good to see you, Vlad.
Good to see you.